So, we have a massive breaking update in the war to end the NFA's stranglehold on your rights. For the first time in nearly a century, the Department of Justice has done the unthinkable. In a stunning legal pivot that has sent shockwaves through the Second Amendment community, the Trump DOJ just officially conceded that suppressors are protected arms under the Constitution. This wasn't some passing note buried in a 200-page legal brief. No, this was a direct admission that fundamentally challenges decades of government policy. This should have been the end of it, a total victory for gun owners. But instead, it just triggered one of the most dangerous court rulings we've seen since Bruin. The Fifth Circuit Court of Appeals just issued a unanimous decision that doesn't just uphold the NFA, it provides a blueprint for the government to tax and regulate every single firearm you own into oblivion. You need to hit that subscribe button right now, because what just happened to a man named George Peterson in Louisiana is about to become the new reality for every gun owner in America. For 90 years, the government's line was simple: suppressors aren't arms. They called them accessories. They called them tools. They argued they didn't deserve a shred of Second Amendment protection. But in the case of United States v. Peterson, the Trump DOJ just walked into court and threw that entire playbook in the trash. They officially admitted that suppressors are bearable arms in common use for lawful purposes. To put that in perspective, there are now over 4.8 million registered suppressors in civilian hands across the United States, with 500,000 more being added every single year. These are arms in common lawful use, which under the Supreme Court's landmark decision in Bruin means they're presumptively protected. By admitting they are arms, the government conceded that under the Bruin standard, these items have constitutional protection. But here is the betrayal. In the very next breath, the DOJ argued that even though you have a right to own them, the government can still make you pay a tax, submit your fingerprints, wait 6 to 12 months for a background check, and put your name on a federal registry before you can exercise that right. Yes, you heard that right. They basically said, these are your constitutional rights, but we can still impose thousands of dollars in taxes, months of waiting, fingerprints, and federal approval before you can exercise them. They are trying to rebrand the National Firearms Act not as a restriction, but as a shall-issue permit scheme. It's like being told you have a right to free speech, but you have to pay a huge tax and wait half a year before you're allowed to say anything. And wait until you see how the Fifth Circuit responded to this absurdity. Think about how absurd this is. The DOJ is claiming the NFA is just a reasonable permit system. But look at the history. When Congress passed the NFA in 1934, they didn't want a permit system, they wanted a ban. The $200 tax in 1934 is equivalent to roughly $4,000 today when adjusted for inflation. That might sound small when you hear $200, but in 1934 dollars, that's equivalent to about $4,000 today. The lawmakers back then explicitly stated on the record that they wanted to make these items so expensive that average Americans could never afford them. It was a wealth-based barrier to a constitutional right, designed specifically to price ordinary Americans out of owning these arms entirely. The Congress of that era was crystal clear. They wanted these items so expensive that the average American simply couldn't afford them. If the government admits you have a right to a suppressor, how can they justify a scheme designed specifically to prevent you from owning one? The DOJ's logic is that as long as they eventually say yes to law-abiding citizens, the burden doesn't matter. They claim that with a current approval rate of around 99% for eligible applicants, it's just a reasonable permit system. But that statistic masks the reality. The application process is cumbersome, expensive, and invasive. You have to submit fingerprints, photos, wait 6 to 12 months, and pay hundreds of dollars. Only the most persistent and often wealthiest citizens navigate the hurdles successfully. If the Fifth Circuit buys this logic, it doesn't stop at suppressors. It reads a pay-to-play model for the entire Second Amendment. But what happens when a court that is supposed to be pro-gun decides to ignore the history and side with the bureaucracy? The Fifth Circuit just handed down a unanimous decision that is so legally flawed it has left Second Amendment scholars speechless. All 3 judges on the panel agreed that, despite suppressors being protected under the Second Amendment, the NFA doesn't violate the Constitution. Let that sink in. This is the same Fifth Circuit that has previously struck down laws restricting 18 to 20-year-olds from buying handguns. Yet in this case, they gave the government a pass. They didn't just uphold the NFA, they gave the government a cheat code to bypass the Bruin test entirely. And the worst part? The man at the center of this, George Peterson, is currently facing 2 years in federal prison. For for a device the government now admits is a protected arm. The legal battle in United States v. Peterson has been a roller coaster that should terrify every gun owner. Initially, in February 2025, the Fifth Circuit ruled that suppressors aren't even arms. They claimed a suppressor is just an accessory because it doesn't cast or strike like a weapon. But then, the political winds shifted. After the Trump administration took office, the DOJ did something truly bizarre. They filed a supplemental brief admitting the court was wrong. They conceded that suppressors are protected arms. You would think the court would then strike down the NFA, right? Wrong. Instead of a victory, the Fifth Circuit panel doubled down. In a revised December 2025 opinion, they essentially said, fine, even if they are arms, the NFA is still legal. Their reasoning? They categorized the entire NFA registration and tax scheme as a shall-issue licensing regime. Here is the cheat code they used. In the Bruin decision, Justice Kavanaugh wrote a concurrence suggesting that shall-issue carry permits, where the state must give you a permit if you pass a background check, are generally constitutional. But here's the problem. Bruin envisioned a simple, minimal-fee background check process. It did not envision a decades-old tax and registration scheme designed to keep ordinary Americans out. The Fifth Circuit took that small window and blew it wide open. They ruled that because the ATF usually approves NFA applications for law-abiding citizens, the $200 tax, the fingerprints, the photographs, and the year-long wait times are just ancillary regulations that don't violate the Second Amendment. Think about the precedent this sets. If the NFA, a law explicitly designed in 1934 to be so expensive and burdensome that it would eliminate these firearms, is now considered a reasonable shall-issue system, then nothing is off-limits. The court literally said that because George Peterson didn't prove the NFA was abusive as applied to him, his conviction stands. He's going to prison for 2 years for possessing a black cylinder. The government now admits he has a right to own, but wait until you hear the specific situation George Peterson is in. He isn't just a case number or a legal footnote. He's a real person facing a nightmare that feels almost surreal. He operated a home-based federal firearms license in Louisiana. In his safe sat a single unregistered suppressor, something that, according to the DOJ's own admission, is a constitutionally protected arm. Yet after the Fifth Circuit upheld the NFA, Peterson suddenly found himself on the brink of federal prison. His attorneys immediately filed for en banc review, asking the full Fifth Circuit to reconsider the 3-judge panel's decision. That request was denied. Next, they filed a motion for a stay of the mandate, essentially asking the court to pause the enforcement of the ruling until the Supreme Court could weigh in. The motion was unopposed. Even the Trump-era DOJ agreed it was reasonable to let him remain free. But here's the shocking part. The Fifth Circuit denied the stay anyway. 2 sentences, no explanation, just denial. Think about that for a moment. The government acknowledges the suppressor he possessed is constitutionally protected, yet he could still be forced to self-surrender and report to prison, even while the Supreme Court considers the legality of the law he allegedly violated. This is a textbook example of the tension between constitutional principles and bureaucratic enforcement. This isn't just about suppressors. If this logic holds, it is a direct threat to your AR-15s, your handguns, and your magazines. Why? Because anti-gun states like New York, California, and Illinois are already watching. If a federal court says the government can tax a protected arm $200 and put you on a registry, what's stopping a state from requiring a $500 permit to own for your Glock? Or a year-long waiting period for an AR-15? By calling these shall-issue schemes, they bypass the Bruin historical test entirely. They don't have to find a law from 1791 anymore. They just have to show that they eventually say yes to some people. The Fifth Circuit just gave the ATF a permanent green light to keep the NFA registry alive, and worse, they've invited every blue state in the country to create their own mini NFA for standard firearms. Some states are already testing this approach. Illinois recently passed laws requiring registration and fees for certain semi-automatic firearms. They're citing this permit scheme precedent as a defense against constitutional challenges. Maryland and New York already have expensive, slow handgun permitting systems. Under this new reasoning, those schemes could be entirely constitutional, despite creating huge barriers for average Americans. California, New York, and New Jersey have been trying to outright ban certain firearms. If this precedent spreads, they could pivot instead to permit schemes, charge high fees, impose long waits, require inspections, and still comply. with constitutional standards, but there is a massive internal conflict brewing. Even though a three-judge panel issued this ruling, some judges within the Fifth Circuit are reportedly furious that the panel ignored the clear instructions of the Supreme Court to look at history and tradition, not just administrative burden. And here's where the government's argument completely falls apart. Under the Bruin Standard, any modern gun regulation must align with America's historical tradition of firearm regulation. Courts are instructed to examine whether similar laws existed at the founding in 1791 or during Reconstruction in 1868 when the 14th Amendment was ratified. Here's the problem for the government. The NFA was enacted in 1934 to 143 years after the Second Amendment and decades after Reconstruction. Suppressors were invented in 1902 by Hiram Percy Maxim, and for the first 32 years of their existence, Americans could purchase them through the mail with no paperwork, no taxes, and no government approval. Suppressors were marketed in sporting goods catalogs, often alongside hunting rifles, as a courtesy to neighbors so gunfire wouldn't disturb anyone. They were in common use for lawful purposes, including hearing protection. There is zero founding-era history of taxing, registering, or forcing shall-issue permits on hearing protection. The government has argued that suppressors fall under a historical tradition of regulating dangerous and unusual weapons. But here's key point. Suppressors are not unusual or dangerous in the sense meant historically. Millions of Americans own them today, and multiple studies show they reduce hearing damage caused by gunfire. Exactly the type of lawful use Bruin considers protected. By admitting suppressors are arms, the DOJ has effectively walked into a trap of its own making. They've admitted the right exists. Now they have to explain why a $200 fine to exercise that right is constitutional. Spoiler alert, they can't. But wait until you see the revenue trap the ATF is using to make sure that never happens. Why is the government fighting so hard to keep suppressors under the thumb of the NFA? Follow the money. In fiscal year 2024 alone, the ATF raked in over $145 million in NFA tax stamp revenue. That is a massive jump from just a few years ago. The NFA has transformed from a crime-fighting tool into a cash cow for the federal government. The DOJ wants to preserve convictions obtained under the NFA. The ATF relies on tens of millions of dollars in tax revenue from NFA items. This makes Supreme Court intervention not just a legal necessity, but a critical safeguard against bureaucratic overreach driven by profit. But here's the irony. Under the Bruin Standard, the government cannot justify a regulation simply because it makes them money or makes their jobs easier. They have to prove it's consistent with the historical tradition of this country. And as we've seen, there is no historical justification. Ion. As we speak, the battle for George Peterson's freedom and your suppressor rights is moving to the highest court in the land. Peterson's legal team, backed by the Firearms Policy Coalition, is preparing an emergency application to the Supreme Court. This application will land on the desk of Justice Samuel Alito, who oversees the Fifth Circuit. Alito has been a lion for the Second Amendment, and he has a choice. Let a man go to federal prison for possessing an arm the government admits is protected, or freeze the lower court's ruling and take the case. Justice Alito has a long record supporting Second Amendment protections and has the power to grant a stay on his own or refer it to the full court. If the Supreme Court grants certiorari, this will be the most significant NFA case in American history. It wouldn't just be about George Peterson. It would force the justices to decide if the entire NFA framework, the taxes, the registries, the months of waiting, is a shall-issue dream or a Second Amendment nightmare. This would be the first major opportunity since Bruin to directly test the constitutionality of any NFA restrictions. A win here doesn't just deregulate suppressors. It breaks the spine of the NFA for short-barreled rifles, short-barreled shotguns, and potentially machine guns. Think about the high-stakes scenario. Best case outcome. The Supreme Court rules that NFA restrictions are unconstitutional for suppressors. This would immediately impact other NFA items. ND could set a precedent limiting states' ability to impose heavy permit schemes. Peterson would be free, and constitutional protections would be reaffirmed nationwide. Worst case outcome, the court defers or denies review, leaving the Fifth Circuit's logic intact. This would give states and the federal government a blueprint to regulate firearms under expensive, time-consuming permit schemes, effectively creating barriers to gun ownership for ordinary Americans. Middle ground, the court could issue a narrow ruling, potentially restoring rights for suppressors only, leaving other NFA items subject to restrictions. The stakes couldn't be higher. We are at a crossroads. On one side, you have a government that wants to turn every constitutional right into a permitted activity that you have to pay for. On the other side, you have the clear text of the Second Amendment. If we allow the Fifth Circuit's shall issue logic to stand, the NFA won't just stay the same, it will expand. You'll see NFA-style registries for your AR-15s and your high-capacity magazines in every state in the Union. But if we win, we finally end the stranglehold that began in 1934. George Peterson is facing 24 months in a federal cell so that the government can protect its registry and its revenue stream. We cannot let his sacrifice be in vain. This case is the ticking time bomb that could finally blow the NFA wide open. This is the battle we've been waiting for. The DOJ blinked and admitted Suppree. SSORs are protected arms. The Fifth Circuit flinched and tried to create a loophole. Now, it's up to the Supreme Court to finish the job and restore constitutional protections to millions of Americans. If you want to stay on the front lines of this fight and get the updates the mainstream media refuses to cover, you need to subscribe right now and hit that notification bell. I'm going to be tracking every single filing at the Supreme Court, every word from Justice Alito, and every move by the DOJ. We are entering the endgame for the NFA. This isn't just theory. People like George Peterson are facing prison because of the current legal landscape. Your rights may depend on how informed and engaged you are over the next few months. Don't miss the next update, because your rights and the future of the Second Amendment are on the line.